Welcome to the session on Industrial Employment Standing Orders Act. Actually, this act is more or less supplementary to the Industrial Disputes Act, what we discussed in the earlier chapter. You see, it is extremely important for any employer to precisely define the service conditions of workmen employed by him. It is very much required. Hence, this act mandates the employees in industrial establishment to formally define the conditions of employment under them. Though this is the purpose of the act. This act applies to every establishment wherein 100 or more workmen are employed or one employer employed in the preceding 12 months. But however, the government, it being the state government, is vested with the powers of reducing the numbers not less than 50. That's why we find some of the state governments have fixed 50 as the criteria for application of the act, and some state governments have still at 100, so it varies from state to state. But the law is very clear, it cannot be less than 50, so 50 is the minimum. So depending on that, the state government shall decide the applicability of the act in the particular state. Here the industrial establishment has been defined as an industrial establishment as defined under the Payment of Wages Act, under Section 2 of the Payment of Wages Act, a factory defined under the Factories Act, a railway as defined under the Indian Railways Act, and an establishment of a person for the purpose of fulfilling contract of owner of any establishment, employee, workman. This is the industrial establishment definition. Now, the question is, how does the act is applicable in case of shops and commercial establishments? Because nowhere it is mentioned in the Applicability Act about the application of the Shops and Commercial Establishment Act. The shops and commercial establishments are governed by the Shops and Commercial Establishment enacted by the respective state governments. The definition of shops and commercial have a very wide coverage and includes various types of business activities today. Every segment of business activity other than a manufacturing activity comes under the bracket of shops and commercial establishment act. That's why we find today even the IT companies, ITS companies, BPOs or any transport companies, any matter as a matter of fact, they all come under the definition of shops and commercial establishment, under the purview of shops and commercial establishment act. And all such have no doubt they fall under the definition of industry under the Industrial Disputes Act, because if we recall the discussions we had in defining what is an industry, and since all the parameters of definition of industry is also applicable here, definitely all commercial establishments are industries within the meaning of the Industrial Disputes Act. But however, this act says industrial establishments pay under the Payment of Wages Act, that's what it stipulates. Hence, what happens is that normally, in all the cases, in the Shops and Commercial Establishment Act itself, there will be a clause inserted to say that for the purpose of industrial establishment, definition of industrial and standing orders, this establishment shall be deemed to be industrial establishment under the Payment of Wages Act. So there will be a specific provision made in the shops and establishment about the applicability or deemed applicability of the provision of the Payment of Wages Act to say that it is an industrial establishment. Like that, the connectivity is developed. Hence, what happens is that if there is a provision in the Shop and Establishment Act, then actually the particular establishment is an industrial establishment falling under Payment of Wages Act, and immediately the Standing Orders Act becomes applicable. That's why today we find the standing orders applicable to even the IT companies, ITES companies, or any other related activities. It becomes applicable. Here the definition of wages and workmen are exactly similar to what we discussed under the Industrial Disputes Act. Hence, I would not like to go through once again the definition of workmen, because we have discussed in the Industrial Disputes Act about the definition of workmen and the wages. Same thing is applicable. So in other words, it means that the standing orders is applicable only for the workmen defined under the Resource Act. It means that the supervisory and managerial personnel, they are out of the purview of this Standing Orders Act. Now, there is a schedule. There is a schedule mentioned. It means that whenever we draft the standing order, we need to draft as per the schedule provided under the Act. The schedule provides various parameters based on which there is a model standing orders also. Based on the entire thing, we need to draft a standing orders to suit our requirement. Broadly, the schedule contains the classification of workmen, matter of intimating the workplace, workmen periods and hours of work and holidays, paydays, etc., shift working, attendance and late coming, conditions, procedure for applying leave, authority which may grant leave and holidays, requirement to enter the premises through gates, exit, etc., liability for search, then closing and reopening of sections of industrial establishment, temporary stoppages of work, rights of liabilities of the employer and workman arising out of therefrom, then termination of employment and notice thereof, then suspension, dismissal for misconduct and acts of misconduct, and what are the acts constitute misconduct, it has to be listed down. Then means redress of workman against unfair treatment, wrongful extraction by employer, there is also provision. Then age of retirement or superannuation or any other matter which may be prescribed. This is the schedule. Within these parameters, one needs to draft its own standing orders. Then once the standing orders are drafted, as per the schedule and in line with the model standing orders, the draft has to be submitted to the certifying officer. Normally the certifying officers are the deputy level commissioner of the region, and if there is a union, a copy has to be served to the union also, and 5 copies to be submitted to the certifying officer. And it's the duty of the certifying officer to call the parties and have deliberations, discussions on the entire draft, and after thorough discussions and approval, he can certify, and he can also suggest modifications which is acceptable to both the parties. It can be done, but he cannot insist or to put any other item other than what is mentioned in schedule. He cannot import extra provisions what is not available in the schedule or in the model. He cannot do it. So within this, he has to certify. Then after certification is done, both parties have an appeal. If they have got to make an appeal, within 6 months they can appeal and ask for any modification if required. Otherwise, it becomes an applicable standing orders. This provision also stipulates that group of employers in similar industrial establishment may submit a joint draft standing orders in this section. This section 3(4) that suggests this. It means, let's say, take an example for instance now, all the garment factories located in a particular city, maybe because they are engaged in similar activity, maybe they can join together a group of employees, they can submit a common standing orders and get it certified applicable to all the industries. Similarly, IT companies, all the IT companies can join together and submit one common standing orders and make it applicable. It's quite possible. Of course, they're rarely done, but there is a provision under the Act that the employees can jointly undertake and do this also. A group of similar establishment, they can draft and then do that. Now, interpretation of standing orders. Actually, there is no provision in the Act, either expressly or in the implication, restrict the scope of standing orders to acts of misconduct within the premises only. On the other hand, if the misconducts take place outside the premises of the factory, but it is connected with the running of the establishment or business establishment, then though the misconduct happened outside the premises of the factory, still the act of misconduct comes within the bracket of this misconduct and the action can be taken. So this is one thing, and it is upheld by Aluminium Industries versus Union versus Aluminium Industries in Orissa High Court. Then Hence, it cannot be held that even if the model standing order taken as a guide, the provision in the standing order for regulating workmen outside the factory and has to justify the interference under Article 226. Then the item of transfer was all along existing in the standing order board. Here the transfer is not in the schedule. We can see that in the schedule what we just read out now, transfer is not there because transfer is an implied condition of service. It is not necessary to document it in say because transfer is an incidental to the job performed by him, and it is the main one of the functions of the management because the transfer is considered one of the functions of the management and it is a implied service conditions. Hence, though it is not mentioned in the standing orders, a transfers can be carried out and it need not be incorporated in the standing orders. But of course, many times in the standing orders, we also make sure that this clause is inserted and it is incorporated, or in the settlements, so we arrive at this with the workmen, then we include a clause of transfer, or in the letter of appointment also we include a clause of transfer. Then what happens? The transferability will not be questioned by anyone. This same case has been upheld by in case of UP Sugar Corporation by Allahabad High Court, and they are upheld by many high courts as a matter of fact. Now, there is nothing like automatic confirmation by probationer after the expiry of the period of probation, unless the terms of appointment clearly indicate that the confirmation will be automatically followed at the end of the specified probationary period. Unless it is mentioned, he may continue still as a probationer. Then he cannot raise he cannot make a grouse, he cannot raise a dispute under the standing orders because the standing orders do not entertain any complaints of whatsoever nature like that. If there is a contravention of the standing order according to him, he has to raise an internal dispute and then say that he has not been confirmed. That can be a matter of dispute before various authorities, he can take it up, but not permissible under the Standing Orders Act. So as I told the appeals, Section 6 permits appeal by workmen and trade union in the prescribed prescribed representative workmen agreed by the order certifying officer. They can always make an appeal within a period of 6 months and they can hear. Otherwise, afterwards, it becomes a permanent standing orders. So, duration and modification of standing orders. Unless there is applied for modification of standing orders, the certificate standing orders shall be valid all through. In case one of the parties or both the parties wants to modify the standing orders, then they have to do the same process of law. In the sense, they have to make 5 sets of the proposed amendment and submit to the certifying officer and have deliberations before him and go for certification, and if the certifying officer approves it, then modification automatically takes care of it. Then in the standing order also, there will be a clause on payment of subsistence allowance. It means that if a worker is suspended pending inquiry, he has to be paid subsistence allowance at the rate of 50% of the salary. It means the gross salary, 50% of the gross salary is subsistence allowance for first 90 days. Thereafter it goes to 75% and thereafter it goes to 90% if the delay is on account of the fault of the workman. If the inquiry gets delayed, if the fault of the workman, then the allowance will be reduced. But if the fault of the workman, I think I made a slight error in the earlier stage, the allowance increases from 50 to 75 to 90 if the delay is on account of the management. But if the delay is not on account of the management, on account of the workman, the allowance shall be restricted to 50%, not more than that. In fact, many of the state governments also have enacted separate legislations governing the payment of subsistence allowance by respective governments. Many state governments have done it, and even if they are not done under it, the standing orders, what has been incorporated here, that takes care of the entire thing. Then till the certification is done, it means that because naturally it's a process, because we need to make 5 sets copies and distribute it, and deliberations go on. The meeting, the whole process may take at least sometimes, delay also will be there in proceedings by certifying officer before he certifies the standing orders. So in such case, till the standing orders are certified, the model standing orders prevails. Mandatory standing still holds good till the final certification is carried out. Then here, certain section 33 stipulates interpretation of standing orders. Here, the Labour Court has to hear the both parties and decide the question, and decision is binding on the parties. It is only a question of interpretation by the appropriate authorities like the Labour Court. For instance, now I give the example of within the premises or precedents of the establishment. Refer to the place and where the act which is subversive of discipline or good behavior is committed, but where the consequence of such act manifests itself. The assault had taken place outside the mill premises, it must be held that the assault being connected to the performance of the officer's duty. Here the question of interpretation. Here the interpretation is to be done by the authorities, judicial authority like Labour Court, Tribunal or the High Court. Because there is no such machinery available under the Standing Orders Act for any kind of interpretations. For interpretation of any standing orders, the approved authorities are the adjudication authorities. When the dispute involves recognition, observation and enforcement of rights and obligations created under that can be called as a sister enactment to ID Act. It means that we need to provide, there is no forum to provide such dispute under this Act, but the only remedy is to approach under the Industrial Disputes Act. This is about the Rajasthan case. In the case of Supreme Court, they were held in 1995, saying that this Act do not have any forum for resolution of such disputes. The only thing is we need to go to Industrial Disputes Act for the purpose of settlement of the dispute. So the language of Section 38 does not spell out. This is one of the case, same thing what I told you just now, is related by again by Gujarat High Court in the case of Amin John versus Boroform Chemicals. He said the language of 38 does not spell out any power for the Labour Court to accord a relief either on the basis of standing orders or the functions of labour limited only to the question of as to appropriate application and interpretation. That's all. Even in the case of Tamil Nadu versus what is the report, is an establishment in work related to operation connected with supply of water being carried on, and consequently the board is an industrialized with the meaning section 2 of the Payment of subsequently Act will apply. Again, interpretation by the Supreme Court. Here the model standing orders you will not apply it to an industrial education institution. That's what is as per Allah High Court. When the probation of service is terminated has placed reliance on the standing orders, the only remedy available is by way of rising industrial dispute. If a probation is terminated and he cannot make any case out of this act, but he has to raise an industrial dispute about his grievance or dispute, whatever it is. When the retirement has been enhanced from 55 to 58 years by amending the standing order, it will not be interfered. The Karnataka High Court in UK, they say that it is upheld. The certifying officer can always suggest enhancement of the age of retirement from 55 to 50 years. It is not termed as it will not be interfered. Then High Court will not interfere in the order of certifying officer by increasing the age of retirement to 50. Again, another Guwahati High Court on the same lines, they have given saying that certifying officer has got powers to interfere and say increase the age of retirement from 25 to 58, he can do it. Then the item of promotion is not in the standing orders at all. Hence, the contention on the ground of fairness, reasonably should be included, cannot be held to be good. There is no authority to extend standing order to be topics not included in the schedule of the Act. So, promotion cannot be a matter of item in the standing orders. It is purely based on certain criteria covered by the manager. So, this is in short about the Industrial Employment Standing Orders Act. This is almost a sister act to the International Dispute Act.